Hello, this is Evan Taylor. I'm a divorce lawyer in Norman, Oklahoma, and I'm going to do a quick presentation for you about an uncontested divorce. First of all, I want to emphasize that an uncontested divorce is simply an agreed divorce. It means both parties, the husband and the wife, agree that they should be divorced, and they agree about all of the terms. And those terms are going to include such things as how you're going to split up your stuff, how you're going to split up your debts. If you have children, then the issues are where the kid's going to live during the week, what is the schedule when they go back and forth between households, and how are both parties going to provide for the payment of the expenses for the children, as well as for any necessary financial support. Other issues can include alimony, changing your name, or some of the other smaller issues that come up in any kind of divorce. Now, the process takes about 5 basic steps. That is petition, which is the document that's filed with the court, the waiver, which is signed by the other side, the decree, which is the final document presented to the judge, the hearing in front of the judge for the divorce, and then the actual divorce itself when the judge says, you two are divorced. So let's begin with the process here. First is the petition. This is the court document that's filed by the person who's starting the divorce, who's called the petitioner. It's signed by the filer. It's filed in your county of residence, usually in the county where you've been living for the past 30 days. The court clerk charges a filing fee for this document, and that can change from year to year. Currently, it's $193.70. When you file it, you'll need multiple copies for the court clerk to stamp and give you your copies back to give to the other side. And it must contain all of the necessary allegations under Oklahoma law to show that you're entitled to a divorce. Now, the second document here is the waiver. This is the document that's signed by the respondent, which is the other side, which basically acknowledges that there is a divorce on file and there's an agreement, and that the other spouse is interested in getting the divorce done. It has to be notarized, and it can't be signed any earlier than 24 hours after the filing of the petition. So you can't sign this before the petition's filed or even the same day. And it can be signed along with the decree, and usually in our practice, we like to submit them both at the same time. Now, the decree is the most important document because this is the document that contains all of your agreements related to the divorce and actually grants the divorce to the parties. It's signed by both sides. It contains all of the agreements, as I've said, so if there's something important, it needs to be in the decree. And it's signed by the judge at the divorce hearing. Now, if you have children, there are some other factors that come into play. You may have additional documents beyond your decree, which would include a joint custody plan, which is an actual agreement between the parents that describes how they're going to care and support for their children, a visitation schedule, which sets out that physical schedule about where the children are going to be on holidays, during the weeks, and the summers, a child support computation, which is using state guidelines to show what the amount of state ordered child support would be. Also, and under Oklahoma law, unless the judge waives it, you can't have a divorce sooner than 90 days from the time the petition is filed. Some judges will waive this, and that's usually in counties involving where the court has set up a requirement to attend parenting classes. Not all counties are this way, but many counties require that each parent attend a class for divorcing parents. And I know in our county, Cleveland County, they do require that you have taken this class before the judge will even consider waiving your 90-day period. Now, also, if you have retirements, the decree may not be enough to actually make the division of the retirement, which means you're going to give a part of that retirement to the other spouse. Certain types of retirements require an order that's called a qualified domestic relations order, usually called a quadro. And also in military retirement situations, there may need to be special language that addresses that, and sometimes that requires a separate order. Now, in Oklahoma, before you can have a divorce, you must have a hearing in front of the judge. This is a simple and short hearing that only one of the spouses has to attend. Usually the person who's filing will attend it. As we said, one spouse attends. The judge has to hear testimony. So you'll generally answer questions asked by your lawyer. The judge will then sign the decree and then pronounce you divorced. The divorce is then final immediately after the judge has spoken it, and the only restriction is you can't remarry anyone but your former spouse in the next 6 months. That's basically the process. I think it's very straightforward. If you have any questions, you're welcome to contact us at contact@microdivorce.com, and we'll try to get them answered for you. So, good luck.